Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode will be somewhat different from our normal format, as we will be taking a look at two different police interactions rather than just one. Think of this as something of a double feature. The two interactions are not related, but you basically get to enjoy two episodes of ATA instead of just one. So be sure to stick around and check out both interactions. The first episode covers disturbing the peace, assault and battery, and fighting words, and is brought to us by M Live's channel. Be sure to check out the description below and give them the credit that they deserve. Around 10:30 p.m. on Saturday, September 17th, 2022, 18-year-old Travis Cram, 19-year-old Parker Wieland, and 18-year-old Gabriella Ricopati were riding rented scooters on the roadway outside of Bay City Public Safety Director Michael Cecchini's apartment in Bay City, Michigan. Director Cecchini believed that the teens were making too much noise and yelled down to them from his apartment. Words were exchanged, and Director Cecchini left his apartment to confront the teens directly. A portion of the exchange that followed was filmed by Ms. Ricopati.
I'm gonna beat your ass, and then I'm gonna take you to jail.
What? What'd I do?
Get out of here.
I didn't even do that.
Yeah, you did.
What'd I do?
Go.
What'd I do?
Go.
That battery?
Get out of here. It's disturbing the peace.
You hit me because of disturbing the
Yeah,
peace.
it's a crime. You need to go.
How did I disturb me? I didn't see anyone else wake up.
You need to get out of here. You disturbed my peace. Leave.
You just committed battery.
No.
Yes.
No,
You hit me with a
not.
flashlight. That's
Get
battery.
out of here.
How is that right?
Leave.
Battery, right?
Mm-hmm.
Call the cops.
Yep, that's right. You call the cops.
You just committed battery. You got it?
Chief of police. Call the cops.
That doesn't work that way, dude.
Yeah. You're gonna tell me the law? What, you think some legal scholar on the Supreme Court?
No,
But, like, what are we doing
as
as a league?
police? You can't hit me with
You
a
can't
flashlight.
disturb the peace.
That doesn't
And
mean
you
you
can't threaten to kick.
The
What you
First
got
Amendment. What's the
Really?
First Amendment?
You hit me with a flashlight.
No,
I
you
can
don't
say
have a
whatever I
right to
say.
disturb the peace.
You have a right to
How are we-
Your
how
rights
are we
end when they
disturbing the
You
infringe
hit me
on
with
gun
a
people.
flashlight, bro.
Which
What are you
down-
talking about?
Like,
I didn't even do it. How did you feel threatened, bro? Is it my luscious locks? Are you jealous? You bald huh? I would be jealous too. Look at my the Grinch out here, bro. Call the cops, bro. You committed battery. I can assault you all I
better
want.
back
You gonna
up.
kiss me?
Assault me.
You want to make out? I'll make out with you right now. I sweep both ways, bro.
Go ahead. Assault me.
Back
I'm not gonna touch
up.
you. I'm not gonna touch you. I know
get
better.
out of his face.
I know better, bro.
Hey,
What is
can
he
you
doing
send
to
a
you?
unit down here? I've got 3 hooligans that need to go.
Hooligans, you hit me with a flashlight.
I'm at 9th Street in front of River's Edge.
Pass it up.
You can do whatever you want. Step it up.
I'm not gonna fight you,
Bye.
dude.
Director Cecchini claims that the teens had committed the crime of disturbing the peace based on the noise they were making and hits Mr. Cram with his flashlight. Now, we will explore whether Director Cecchini's actions constituted a battery, as Mr. Cram claimed later in this episode, but we will first discuss whether the teens could be guilty of disturbing the peace. According to Section 54-48 of the Bay City Code of Ordinances, quote, "It shall be unlawful for any person to disturb the public peace and quiet by making or causing to be made loud noise so as to unreasonably disturb the quiet, comfort, and repose of persons in the vicinity." Section 54-49 of the city ordinances expands on the definition of unreasonable noise and identifies a variety of acts that are declared to be quote-unquote unreasonably disturbing loud noises in violation of the ordinance, including, now quoting, yelling, shouting, hooting, whistling, or singing in the public streets between the dates of April 1st and November 1st, particularly between the hours of 11 p.m. and 7 a.m., or at any time or place so as to unreasonably disturb the quiet, comfort, or repose of any persons in the vicinity. Now, while the noise in question occurred before 11 p.m., depending on the volume of the noise the teens were making and the disturbance caused by it, it is possible that a court would find that they had quote-unquote disturbed the peace in violation of the Bay City Ordinance. However, because the noise was not captured on camera, I cannot accurately hypothesize how a court would decide on this issue. After Director Cecchini called the police, 2 officers with the Bay City Public Safety Department responded to the scene, and their investigation was captured on their body cameras.
Well,
Okay,
I'm
I can
talking to
talk.
him. No, you're not
Let
talking.
him talk first. Let him talk first.
Let him talk.
Okay. Yeah.
All right.
Thank you.
You're welcome.
Disturbing the peace. Both of them squealing their wheels at me. He come-
Stop. He's talking.
Okay.
Travis.
They come here, they hit the cone, they're messing around here around this new monument. It went on for about 5 minutes. Okay? I'd had enough. I'm upstairs. all right? I said some bad words, all right?
Okay.
He challenged me to fight and dared me to come down, okay? I came down, he stood off on me, and I did a pectoral jab with my flashlight.
Okay.
Okay?
Okay.
Okay.
My
What?
side?
Okay.
My side first, right?
So,
I say
Hold
my
on.
side?
Yes,
Okay.
you do. Just wait.
I'll cut a supplement. 2 charges right here,
Okay.
in my opinion.
Here's the scoop.
But I'll let you investigate it,
Okay.
okay?
Bird scoop.
I'll get their statements. I come check in with you. Okay.
All right, first
Talk to him.
Me?
Yep. Talk.
Okay.
Okay. You got nothing on you?
No.
Okay. All right. What's going on?
So we were just riding around on burn scooters, you know, like teenagers do. And then he came up
How old
here.
are you?
I'm 19.
Okay.
And he hit the cone right here and knocked it over.
What cone?
I think it was the one
Can
with
you
the gray
step
on it.
inside? Okay. Middle one.
Yeah, and knocked it over, and then he started yelling, and he threatened him first. So he was defending himself,
Okay,
like
how-
against him.
How did he threaten him?
I don't remember exactly what he said,
Okay.
but he antagonized him, so he was defending himself.
Okay. What led up to that point?
We were riding around down here. We were going down there, turning around, coming back up here. We were riding around this thing a little bit.
Okay. And then, so you hit the cone, and then what happened?
He hit the cone.
Sorry, that's what I meant to say. He hit the cone, then what happened?
Then he started yelling at us, and he defended himself.
Where did he come from?
He was up there, up at the top,
Okay.
and he was like, "I'll come down there and beat your ass."
Okay.
And we waited down here to see if he would actually come down, and then he came down. Travis was standing right there, didn't say a single
Right where?
word,
Right.
and like on the road, and he came up and hit him. I don't know if it was like in the chest or the rib cage, but he hit him with the flashlight and then started shining it in his eyes.
Mr. Whelan tells the officer that Director Cicchini hit Mr. Cram in the chest with his flashlight, as corroborated by the footage filmed by Ms. Ricopati.
What'd I do?
Go.
What'd I do?
Go!
Take that battery.
Section 750.81 of the Michigan compiled laws states that, quote, a person who assaults or assaults and batters an individual is guilty of a misdemeanor. Now, because the statute does not include definitions of assault or battery, these offenses are outlined by case law. As the Michigan Court of Appeals explained in the 2011 case of People v. Cameron, quote, the courts have defined a battery as an intentional, unconsented, and harmful or offensive touching of the person of another. It does not matter whether the touching caused an injury. The court also expanded on the definition of an assault, stating that, quote, the courts have defined an assault as an attempt to commit a battery or an unlawful act that places another in reasonable apprehension of receiving an immediate battery. Thus, every battery necessarily includes an assault, because a battery is the very consummation of the assault. Accordingly, it is likely that a court would conclude that Director Cicchini committed an assault and battery against Mr. Cram. It is notable, however, that Director Cicchini did not simply batter Mr. Cram with his hand, but hit him with a flashlight. Under Section 750.82 of the Michigan compiled laws, quote, a person who assaults another person with a gun, revolver, pistol, knife, iron bar, club, brass knuckles, or other dangerous weapon without intending to commit murder or to inflict great bodily harm less than murder is guilty of a felony. According to Section 17.10 of the Michigan criminal jury instructions, quote, a dangerous weapon is any object that is used in a way that is likely to cause serious physical injury or death. The instructions further explain that, quote, some objects, such as guns or bombs, are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used in an assault determines whether or not it is a dangerous weapon. Now, while there are ways that a heavy metal flashlight could be used that would likely cause serious physical injury, such as forcefully bludgeoning an individual over the head, in this situation, Director Cicchini jabbed Mr. Cram in the chest with the flashlight. Now, although this action could certainly cause injury, it is improbable that a court would conclude that it was likely to cause serious injury or death, and therefore it is unlikely that a court would conclude that Director Cicchini's actions constituted assault and battery with a dangerous weapon.
You got your ID on you?
Yes.
All right, let me see it. Okay, go ahead. Just
Wait, by the
go on that pole so she can see you. Go sit on that pole, okay?
Bird scooping, right? I was riding. You know how like when you press the brake, the back wheel locks up and it makes a squeaking noise, right?
Okay.
And you can drift when you do that. It's kind of fun. right?
Okay.
I get it's kind of late and stuff, right?
Right.
But he's up there. He goes, "Hey, big shot, you want to go?" Right? Because he said, "Why don't you keep it down?" I said, "I'm not doing nothing wrong." He goes, "Hey, big shot, you want to go?" Right? So, obviously, you know, I'm a dude, 18 years old. I can hold my own ground. I'm gonna hold my own ground, right?
Okay.
So, I didn't know who he was, right? This random old guy, older guy, not trying to be rude, right? So, I said, "Yeah, come down, we can go," right? He's threatening me to fight me, right? And I stood right here. I said, "What's up?" He walks up to me and like, "I'm not gonna hit you, I promise." He goes like that and jabs me like right here in the ribs with the flashlight.
Okay.
And then he said he felt threatened. My hands were at my sides. I don't know. I didn't swing at him. I didn't pick up.
What did you do when he walked down?
I just stood there. I said, "What's up?" Like, I didn't know who he was. He was out his badge. I think he was a cop. I'm not gonna swing at a cop. You know, I have more respect than that. You know, he has
Okay.
authority over me. He's better than me. You know, all I know you.
So he hits you in the stomach with the flashlight.
Like the
then what?
rib cage, not the
Okay.
stomach, bro.
Okay. Not bro, but
I'm sorry.
then what?
And then that's like it. He was like threatening me to swing on him. He wanted me to swing on him,
Why?
right?
How?
Like he would get out. He was like, "I'm not close to you, but like
No,
say this is my face. This was his face." He was like threatening, like, "Swing on me, bro. Swing on me. Swing on me. Come on, big shot. Swing on me."
Did he say that?
Yes. He was like telling me, Gabby, was he not telling
No,
me?
listen.
Sorry.
Hey, I'm talking to you.
Okay,
We'll
yeah.
talk to her.
He was literally telling me to swing on him.
When was this? You didn't mention that before.
It was like after the effect of the like when he came down here and showed me his badge. As soon as he showed me his badge, I was out. Right? I'm not
Okay,
gonna fight a
but-
cop.
So he comes out. You
Yep.
say, "What's up?"
Yep.
Then you told me that he comes up to you and pokes you in the stomach with the flashlight.
Like jabs. It wasn't a
Jab-
poke. Dude. If it was a poke,
sorry,
I wouldn't
okay.
even have made an effect. I would have
Jabs
just left.
jabs you in the stomach with the flashlight. Now
Yep.
you're telling me that he was telling you to swing on him.
That was after.
When?
He jabbed me in the
After when?
stomach, and then he was like, "Come on, big shot," like threatening, like, you know,
What exactly did he say though? Right?
like
'Cause
hit
you
me.
said a couple
So I was
times.
mad, right? I'm mad, right? He jabbed me in the stomach with a flashlight.
So what did you say when he jabbed you?
I was like, I don't even remember. I think I said something about like I should fight him, right? Because that's battery. No, I said that's battery, right? Because
Okay.
that's battery, right? Is it not?
Okay.
Hitting
And
with
then-
an object is battery.
And then what?
And then I just walked away. I walked that way. I walked to the other side of that.
No. You say something to him.
I
and
said,
then
"That's
how-
battery."
and
And
then-
he said, "No, it's not. You're going to jail for disturbing the peace."
Okay.
I said, "That's not a jail-worthy crime."
Okay, but where does
Right?
the swing on me, hit me?
Okay, it goes after, because I was talking to him, right? I was like, I'm kind of mad, bro. I could fight someone right now.
Don't reach in your pocket.
I'm so sorry. I was out of pocket. Anyways, so I was like, I should fight you. To him, right? I should fight him, right? He hit me with the flashlight. That's
This is
self-defense.
after the fact?
Yes, way after, like
Okay.
probably 5 minutes after, right? He's like, I should hit him back. This self-defense. If he hits me with a flashlight, I'm an unarmed dude,
Where was
right?
he when you were saying this? Where were you?
Like right there. He was like right there, right? And we were
Okay.
on the other side of, you'll see that little circle
So then
thing.
you guys are talking and you say you should hit him.
I'm mad. Like I could hit him.
Okay, then
Right?
what?
And he runs up to me, like not runs, but like fast walks up to me. He's like, hit me. And like points toward his chin. Like I'm gonna hit him. And I said, no, I'm more mature than you, or I'm not gonna hit you. And he goes, hit me. And I'm like, I'm not gonna hit you.
Mr. Cram explains to the officer that Director Cicchini kept telling him to hit him, although he could not remember exactly what words Director Cicchini used. Fortunately, Ms. Ricupati also captured this part of the altercation in her recording, which shows that Director Cicchini repeatedly told Mr. Cram to quote-unquote assault him.
Call the cops, bro. You committed battery. I can assault you all I want.
back
You're gonna
up.
kiss me?
Assault me.
You wanna make out?
Assault
I'll
me.
make out with you right now. I swing both ways, bro.
Go ahead. Assault me.
I'm not
Back
gonna
up.
touch you. I'm not gonna touch you. I know
Get
better.
out of his face.
I know better, bro.
Now, while most speech is protected by the First Amendment, as the Supreme Court explained in the 1942 case of Chaplinsky versus New Hampshire, quote, "It is well understood that the right of free speech is not absolute at all times and under all circumstances. There are certain well-defined and narrowly limited classes of speech, the prevention and punishment of which have never been thought to raise any constitutional problem. These include the lewd and obscene, the profane, the libelous, and the insulting or fighting words, those which by their very utterance inflict injury or tend to incite an immediate breach of the peace." In the Chaplinsky case, the court defined the category of unprotected speech known as fighting words as those that are, now quoting, likely to provoke the average person to retaliation and thereby cause a breach of the peace, and determined that calling someone a quote-unquote damned racketeer and quote-unquote damned fascist was not protected by the First Amendment under this exception. Over time, courts have narrowed the scope of the type type of speech that is considered unprotected fighting words, with the Supreme Court describing the exception in the 1989 case of Texas versus Johnson as speech consisting of, now quoting, a direct personal insult or invitation to exchange fisticuffs. Accordingly, because Director Cicchini was in Mr. Cram's face, explicitly challenging him to quote-unquote assault him, it is certainly possible that a court would find that this speech fell into the fighting words exception and was therefore not protected by the First Amendment.
I hit him, right? So, yeah.
Then what happened?
And then you guys got here. And I asked him if I could sit down. He said, you're free to do whatever you want. I walked over here. I seen you guys pulling up, and I stopped. Now I'm here. I didn't threaten him in any way. I don't know how he feels threatened.
So the original altercation was because you were
Squeaking the tires on the bird
and he
scooters.
yelled at you from up there.
Yeah, is that a worthy thing to hit someone's flashlight?
It's
Because he's
not
chief of police? He's above me? He's better than me?
On September 18, 2022, the day after the altercation, city leaders received a citizen complaint about Director Cicchini's conduct and placed him on administrative leave. On October 2nd, while he was still on leave, Director Cicchini announced his retirement. The Bay City Public Safety Department requested that the Michigan State Police investigate the matter, and state investigators sent a report of their findings to the Bay County Prosecutor's Office. The Bay County Prosecutor asked the Michigan Attorney General's office to appoint a special prosecutor to review the case. And on January 23, 2023, Attorney General Dana Nessel announced that former Director Cicchini would be charged with misdemeanor assault and battery against Mr. Cram. On March 5, 2024, Mr. Cicchini entered a plea of no contest to the charge as part of a plea agreement that required the former chief to complete an anger management course, perform 40 hours of community service, and relinquish his Michigan Commission on Law Enforcement Standards license, which would prevent him from working as a police officer in the state. Once Mr. Cicchini completed these requirements, the charge was dismissed, as specified by the plea bargain. On January 25, 2023, Mr. Cram filed a federal lawsuit against Mr. Cicchini, alleging violations of his 4th and 14th Amendment rights. The lawsuit was dismissed on November 9, 2023, after the parties agreed on a settlement, with Mr. Cram being paid $90,000 in total. Overall, Director Cicchini gets an F for maintaining a belligerent and hostile attitude throughout the encounter, instigating an altercation with a group of young people over something as trivial as some noise, and assaulting and battering an 18-year-old to whom he had threatened further physical violence. Although Director Cicchini was off-duty, his actions and demeanor reflected poorly on his professionalism, especially as the chief of the Bay City Department, and demonstrated a severe deficiency of the fortitude and emotional stability that are required for an individual to be an effective police officer. In this instance, Director Cicchini's inappropriate and violent misconduct ultimately cost him his job and his law enforcement license, demonstrating the importance of holding police officials accountable for their actions, both on and off the clock. Mr. Cram gets an A-, because although he was confrontational in his responses to Director Cicchini, it does seem that Director Cicchini was the instigator of the conflict, and Mr. Cram certainly did not do anything that justified Director Cicchini's physical attack on him. Mr. Cram also immediately recognized that Director Cicchini battered him, and exercised an impressive level of restraint by not responding to Director Cicchini's attempts to tempt him to assault him. Finally, Mr. Cram should be commended for taking appropriate action after the fact by apparently filing a complaint, although it is not entirely clear whether Mr. Cram or one of his friends actually filed the complaint, and pursuing a civil rights lawsuit against Director Cicchini. This interaction showcases how essential it is for citizens to know and understand the law, and take steps to pursue accountability when they are victims of crime and their rights are violated. The next episode covers trespassing, handcuffing, and obstruction, and is brought to us by Code Blue Cam's channel. Be sure to check out the description below and give them the credit that they deserve. On September 9th, 2021, during the last few minutes of a Black River Falls High School football game on the University of Wisconsin La Crosse campus in La Crosse, Wisconsin, Officer Ames and Officer Barton of the UW La Crosse Campus Police observed Matthew McCormick walking through a fenced-off construction area. The interaction was captured on both officers' body cameras.
Okay. Back through the fence. Sorry, sir. Gotta have you go around the backside. Through the fence. It's a construction zone.
Yeah, no, I do this for a living.
You work here?
Yes, I do.
On this
I
side?
did that parking lot. I did that parking lot over there.
But not this one.
Are you here for work?
This side?
Yes, I am. I'm here doing a walkthrough to make sure there's no erosion control problems.
Okay. Can I get your ID?
I don't have one on me.
Don't have it?
Yeah.
I can't let you in.
That's mine.
Oh, okay. No.
I'm not resisting.
Stop.
I'm not.
Stop.
Stop, ma'am. Don't.
I'm not resisting.
Stop tensing up. Stop tensing up. Relax.
Quick fork
Just
in my
relax.
arm.
1309 out with one.
Listen, you're the one
Because you're
that...
tensed up, that's why.
No.
Yes.
No, you guys
That is
are the one
why.
that said stop, Jack. Stop.
Stop. Just stop. Relax.
I'm going to put you in handcuffs till we figure out who you are.
After Mr. McCormick directs profanity at the officers and begins to walk away, they detain him in handcuffs, claiming they will do so until his identity is confirmed. Now, we will discuss the use of handcuffs later in this episode, but first, it is important to discuss whether the officers had the authority to detain and identify Mr. McCormick under the circumstances. According to Section 943.15 of the Wisconsin statutes, quote, "Whoever enters the locked or posted construction site of another without the consent of the owner or person in lawful possession of the premises is guilty of a Class A misdemeanor. In order for a construction site to be considered quote-unquote posted under the statute, a sign of at least 11 square inches must be placed in at least 2 conspicuous locations for every 40 acres to be protected. The sign must also include an appropriate notice and the name of the person giving the notice, followed by the word owner or occupant. Likewise, Section 943.13 of the Wisconsin statutes prohibits individuals from entering, quote, enclosed land of another without the express or implied consent of the owner or occupant. The statute also clarifies that, now quoting again, implied consent means conduct or words or both that imply that an owner or occupant of land has given consent to another person to enter the land. And that, now quoting again, in determining whether a person has implied consent to enter the land of another, a trier of fact shall consider all of the circumstances existing at the time the person entered the land, including whether the owner or occupant acquiesced to previous entries by the person or by other persons under similar circumstances, the customary use, if any, of the land by other persons, whether the owner or occupant represented to the public that the land may be entered for particular purposes, and the general arrangement or design of any improvements or structures on the land. It is unclear whether the construction site was appropriately posted or locked, but the footage does show that at least one large sign was displayed on the construction site fence, although the content of the sign is not visible in the body camera footage. And while the campus was held open to the public, it is evident that the university intended to prevent unauthorized individuals from entering the enclosed construction site, indicating that Mr. McCormick did not have express or implied consent to enter. Consequently, a court would likely find that the officers had at least reasonable suspicion to detain Mr. McCormick for potential trespassing. Under Section 968.24 of the Wisconsin statutes, when a law enforcement officer reasonably suspects that an individual is committing, is about to commit, or has committed a crime, they may stop the citizen in a public place for a reasonable period of time and demand their name, address, and an explanation of their conduct. As such, it is likely that a court would determine that the officers had the legal authority to require Mr. McCormick to identify himself, although it should be noted that the statute did not authorize the officers to demand that Mr. McCormick display an identification card, but only to demand his name and address.
Talk to me like a person.
We were.
No, you weren't.
We weren't the ones calling names like you were.
I did not call you a name.
You said multiple profanities.
What I said to you was kiss my... is what I said. I did not call you anything.
Profanity.
You have an ID?
My wife can grab it out of my back pocket for me. Nope, don't grab my wallet. I'll get my ID out for you, sir.
Sir, stop.
Come over here.
Somebody's got an attitude.
I know.
And it's...
Ma'am, you want to grab his ID for me, please?
Thank you. What I said I would do for you, you did for me. Thank you.
Matt, shut your mouth.
I'm not bending over. I'm not kissing anybody. I didn't do anything wrong. I'm not going anywhere. I'm not running from you.
But listen, it's not that. It's because you're in handcuffs. That
it's not a law that if I'm in handcuffs, I can stand on my own, sir.
No, but listen, but if you do fall on your face, it's a liability because you can't catch yourself. So it's not that I think you're running away. It's just a safety thing.
Never called either one of you a name or anything. And you guys are the ones that jump to conclusions and all of a sudden, oh, we got to put you in cuffs. Sorry, I'm just moving around. I can't stand still.
That's fine.
The girl that walked through over there, you didn't do anything to her, did you? You let her go right through.
Because you came in and made the scene.
I told you I was walking through the
I'm going to go work on your citation. We'll call it good.
Do what you got to do, guys.
Yeah.
Seeing that he's going to write out the citation, he knows who I am. Can you take the cuffs off now because I'm not under arrest, correct?
No. We'll just.
Am I under arrest?
You're being detained.
Am I under arrest?
You're being detained.
For what?
You're being detained.
For what?
Okay, we needed to detain you because one
For
escalated
what?
the situation.
What are you detaining
Sir,
me for?
listen,
What are you
I'm
holding me
explaining.
for?
Okay, well,
Just by you saying
you're
detained, you're detained. What are you detaining me for? What did I do wrong?
I was explaining
what
to you.
What did I do wrong?
Okay, sir, if you're going to interrupt me, I'm not going to explain it.
Answer my question
No,
then.
because you keep interrupting.
Because you can't answer the question. I asked you, what am I being detained
Sir,
for?
I'm not arguing with you here.
After being handcuffed, Mr. McCormick asks if he is under arrest, and Officer Ames states that he's being detained. As we have discussed before here on ATA, the Fourth Amendment protects citizens against unreasonable searches and seizures. As such, if a Terry stop is sufficiently intrusive to quote-unquote ripen into a so-called de facto arrest, the seizure can be deemed constitutionally quote-unquote unreasonable if it is only supported by reasonable suspicion and not probable cause. Now, while officers are not permitted to use handcuffs as a matter of course during all Terry stops, the Seventh Circuit, which has jurisdiction over Wisconsin, has repeatedly affirmed the constitutionality of officers using handcuffs when a detainee attempts to flee or poses a flight risk. For instance, in the 1993 case of U.S. versus Wilson, the Seventh Circuit Court of Appeal determined that a suspect's flight and the risk of future flight supported the application of handcuffs during an investigatory stop. In this situation, the officers chose to handcuff Mr. McCormick after he attempted to walk away from them. There is a strong argument that could be made that because the officers did not tell Mr. McCormick that he was being detained, he was not quote-unquote fleeing, but simply attempting to leave after the officers told him that he could not be in the construction site. However, as the Seventh Circuit Court of Appeals explained in the 1994 case of U.S. versus Tillman, the fact that a Terry stop may have been accomplished by quote-unquote less intrusive means does not by itself render the seizure unreasonable. As such, it is still possible that a court would determine that the use of handcuffs was constitutionally reasonable under these circumstances. However, even if a court determined that Mr. McCormick's handcuffing transformed the Terry stop into a de facto arrest, a court could still find the seizure to be constitutional if it also concluded that the officers had probable cause to arrest Mr. McCormick for trespassing. Although Mr. McCormick claimed that he was present on the construction site for work, this assertion seems relatively dubious, as his explanation that he was doing a quote-unquote walkthrough was far from compelling, and the fact that he was with his wife suggests that he was not on the campus in a professional capacity. As the Supreme Court held in the 2018 case of District of Columbia versus Westby, probable cause is not a high bar, and officers are not required to accept a suspect's innocent explanation for suspicious facts at face value. Rather, the court noted that probable cause, now quoting, requires only a probability or substantial chance of criminal activity, not an actual showing of such activity. As such, it is certainly possible that a court would conclude that the officers had probable cause to arrest Mr. McCormick for trespassing, which would make the use of handcuffs almost certainly constitutional.
If you have an issue, this is all being recorded. You can come in tomorrow.
I don't care if it's being recorded. By all means.
Okay. Well, that's where I'll leave it then.
Learn how to do your job.
Okay.
Don't worry, it's going to take a while because he's going to sit in the car just to try to make a point. Pretty funny. All day long, people are walking through here. You guys didn't bother anybody. Not a thing.
Are you okay with standing, sir, or do you want to sit down?
I'm fine.
Okay. Just double checking.
Just find it funny that, other people could keep walking through, no problem.
Sir, just don't lean that way.
I'm turning looking that way.
If you want to look that way, turn the other way. And look the other way. Because now you're facing me. I guess I'll play the game.
What's the difference of me? Are you threatened by me? Really?
Sir,
so I can't even face you.
Okay, I'm not talking.
That's probably the smartest thing you've said all night long.
Appreciate it.
Yep, there you go. What are you jerking me around for?
You're jerking me around.
I can't move? Exactly. So let's play ring around the rosy.
No, we're not, or else you're going to sit down.
I'm standing here.
Okay, well,
not
then stop
bothering
playing
you.
around.
What am I doing? I can't turn to look at something?
What are you looking at?
Whatever I want. Whatever I want.
Okay, I don't understand why this is such an issue.
You guys made it an issue.
No, you did.
No, not at all.
Okay.
Keep telling yourself that.
Well, it's all on camera. Sir, I'm going to have you sit down if you just keep messing around like this. Like, I don't know what the game is.
I told you when I first got here, I can't stand still. I got to keep moving. Okay?
Can you sit still?
No, because I got bad knees.
Okay,
that's why I got to
sit-
keep moving because
listen,
of my
if you sit,
joints.
can you move your legs?
No, I cannot sit.
Okay.
Because I sit all the way down there. It ain't going to be good for my knees. Not going to happen. You could just uncuff me and I'll stand right here and there's no problem. Have I ever once tried to resist you? No.
Well, while we were cuffing you, you were.
No, I wasn't. Your buddy tried tackling me almost. So I said, relax and talk to me. Instead of just snapping. Man. So what do your security guards get paid?
Seriously, Matt, just knock
Just
it off.
asking a question,
Just
trying to make
knock it off.
conversation.
Knock it off.
That's all I was asking. Tony.
Mr. Erickson, now's not the best time, but I appreciate it.
Just a hi.
I know. Thanks, sir.
Yay.
Seriously, I want to go home.
We will.
All right, man, I'll give you his ID back. You can take my handcuffs.
You don't need to explain it, just hand it to me and that's good.
I do need to explain it.
No, you don't. You gave me a ticket. I gotta pay a ticket.
Okay.
Give me my ticket.
I gave you a citation for obstructing a police officer. Okay. Okay.
The officers issue Mr. McCormick a citation for obstructing a police officer in violation of subsection 7 of section 18.10 of the Administrative Code of the Board of Regents of the University of Wisconsin system. This regulation mirrors the language of section 946.41 of the Wisconsin statutes, which states that, quote, whoever knowingly resists or obstructs an officer while such officer is doing any act in an official capacity and with lawful authority is guilty of a Class A misdemeanor. Now, while it could be argued that Mr. McCormick's attempt to walk away from the officers constituted a violation of this statute, according to the Wisconsin jury instructions for obstruction, in order to sustain a conviction, the government must prove that the defendant knew that his conduct would obstruct the officer. And as we discussed earlier in this episode, the officers did not tell Mr. McCormick that he was being detained, and their conduct could reasonably be interpreted as an attempt to remove him from the construction zone if he was not authorized to be there, rather than an investigative detention. As such, Mr. McCormick would have a strong defense if the obstruction charge was pursued based on his attempt to walk away from officers, as he could argue that he did not know his conduct would obstruct them. However, the statute also states that obstruction includes, now quoting, knowingly giving false information to the officer. The Wisconsin jury instructions for obstruction through false information outlines the 4 elements of the offense: that the defendant knowingly gave false information to an officer, that the officer was doing an act in an official capacity, that the officer was acting with lawful authority, and that the defendant intended to mislead the officer. In this instance, Mr. McCormick seemingly provided false information to the officers when he claimed that he did not have an identification card with him, as he later admitted that it was in his wallet in his pocket, and it can be presumed that he did so with the intent to mislead the officers about the fact that he had ID with him. As we mentioned earlier in this episode, Mr. McCormick also may have provided false information when claiming that he was doing a quote-unquote walkthrough of the construction site as part of his employment, potentially in an attempt to mislead the officers into allowing him to cut through the construction site. But it is unclear whether or not any of these statements were false. The officers also appeared to be acting in their official capacity, and a court would likely find that they were acting with lawful authority, as they had reasonable suspicion to detain Mr. McCormick. While the Wisconsin stop and ID law would not authorize the officers to demand an identification card, it is well established that officers do not offend the Fourth Amendment by requesting identification, even in situations where they do not have reasonable suspicion or probable cause to believe that the individual is involved in criminal activity. Consequently, it is likely that a court would conclude that at least Mr. McCormick's false statement regarding his identification card could sustain an obstruction conviction.
Your court date,
Yep.
if you wish to dispute, your court date's October 14th at 2 in the afternoon. Hold up.
Thank you. Gotcha.
Okay.
I'm good to go.
Okay.
I'm good to go.
No,
okay?
I'm going to explain this.
No, I'm done with you. You gave me a
Okay.
ticket.
Can I
I'm
just
gone.
take him home, please?
What's going to happen
Thank you.
is...
There's my wallet. Thanks. Let's go.
Is this
Don't
what-
don't
this-
bother talking to my wife. We're leaving. We're trying to leave the scene here and leave the situation. So let us go, please. That's all I'm asking.
I want you to understand this.
I got it right here.
When the Black River Falls Athletic
I don't
Department
really care.
has contact with your son because of
I
the
don't really
behavior of his
care.
parents,
No.
that's going to be an issue. So that it's got to happen. Because
Here, please leave his dumb ass there and let's go. I ain't putting up with this trick.
okay.
After Mr. McCormick received his citation, he and his wife left campus with no further issues. On October 14th, 2021, Mr. McCormick pled no contest to the obstruction charge and was assessed a fine of $452.50. It is unclear whether Mr. McCormick filed a complaint or attempted to pursue legal action after the encounter. Overall, Officer Ames and Officer Barton get a C+, because although they likely remained within their lawful authority throughout the encounter, they unnecessarily subjected Mr. McCormick to the use of handcuffs. officers. And Officer Barton, in particular, demonstrated a hostile demeanor at various points during the interaction. In my opinion, it is highly likely that Mr. McCormick did not know he was being detained at the time that he attempted to walk away from the officers, as they had never informed him that he could not leave, and actually told him that he could not be in the construction site, and the officers should have allowed Mr. McCormick the opportunity to comply with an order to stop before resorting to force. Although courts have upheld the use of handcuffs during Terry stops under certain circumstances, most citizens associate handcuffing with arrest, and given the demeaning nature of handcuffing, officers should rely on them only when necessary. The rapid application of handcuffs, combined with the proximity of this decision to Mr. McCormick's use of disrespectful language toward the officers, also suggests a potential retaliatory motive for Mr. McCormick's unwarranted handcuffing. This encounter demonstrates how unclear communication and disproportionate escalation by officers can result in an unnecessarily negative interaction with a citizen. Mr. McCormick gets a C, because while he maintained an antagonistic demeanor throughout the encounter and seemingly lied to the officers on at least one occasion, he mostly complied with the officers' orders and submitted to handcuffing without serious physical resistance. Although his criticism of the officers was not pleasant, he remained within his First Amendment rights throughout the encounter. And while I do not know for certain whether Mr. McCormick was lying about walking through the construction site for work, his story seems rather implausible. And I find it hard to believe that a bona fide employee would not be willing to confirm his permission to be present on an otherwise closed construction site to officers attempting to protect the site from trespassers. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.